And this class goes to 10.
Okay.
And there's some really around. This both my classes are pretty good.
Okay. See what we can do. It goes 20 minutes. You're gonna have a lot of time.
Nice. How's business?
Dragging along.
Yeah.
Okay. Keeps me out of trouble. Really consistent. Works out well.
I've added more to my working in charter school. Trying to kick out the it's fun work.
Kick out.
But also another thing in general.
Yeah, we just are more recently, or still moved in more recently, but that's been plenty of things.
Yeah, keep you busy.
Busy with that.
Managing construction.
We're moved or building in now
Yeah.
for a while. So yeah, managing it, and then now it's getting in and getting all the moving in, and then all the odds and ends of getting everything or in place and set up how we want.
Yeah. It doesn't seem like it should be that much work. Like we did a piece a few years ago. It was like nothing gets done. Or somehow it gets up like half a day at lunchtime. You know?
Exactly. Yep. Put the yard in at some point. I mean, it's a bigger or piece of property. It's been crazy. We got secondary water. We'll have to pull some water lines and move dirt around. I'll probably do a combination of some of myself and stuff, but having others do it.
You can't get grass seed to grow. So yeah, you saw it.
We'll see. I don't know for as much short as we want to put it. Sod would be prohibitively expensive.
Yeah.
You're right there with it. I think they're representing Utah this year. Nobody else was pulling a flag.
Hardcore Utah fan.
But a good year for Utah.
His wife will never go to Utah.
You guys have ever seen it? I've been looking for this guy.
Handsome, right?
That's you.
Yeah. He did a lot of Photoshop.
She's got a little.
It's funny, mine, like Eastern European, and like, I don't know if it's a cultural thing or just a problem with him. It's really fired up, and he like really into BYU rivalry, like angry about it. Like, so his wife probably. So it falls to me typically like BYU games, but now I'm like. In the past, I've like stopped fights. Like, okay, well, that's when they're winning. Like, if they get beat by you, I don't want to be anywhere near that.
It's been a rough year for U of U.
Yeah.
A good year for BYU.
Yeah, great year.
I can't complain on that
Yeah.
one. See how this week goes. Still supposed to be the underdog.
I just read too that they're gonna like Ryan Smith is involved. They're gonna pay somebody. Like one of the highest rated basketball recruits. Come to BYU because now you can do that because of the county health system.
Yeah.
They can pay him like $4 million.
Crazy.
Come to BYU.
Huh.
Play basketball.
It's a good deal for him.
Yeah, exactly. Be 18 years old. $1 million.
That's right. Get your school paid for, retire, and just enjoy life. Well, I don't know that it's, or hopefully it's a good rivalry game with you and BYU this year. Hopefully the right team.
At you.
And which is opposite how going into the year it was supposed to be just the opposite, where BYU was not supposed to do well and U of U is supposed to dominate. So
Yep. Yeah, I think I'm gonna be skipping that one too.
that's a little bit.
Be out of town or something. Okay, if this is recorded again.
Yeah.
Okay, it's 9 o'clock. Maybe there's traffic or something. I imagine people will straggle in. I expected the exam scores to fill the seats back up because everybody that's here generally did well. Everybody that's not did not. But I guess we'll see. Anyways, as you know, we have a guest lecture today. Devin Miller from Miller IP is here to speak with you about intellectual property law. I met Devin recently, but although for several years before that, I'd driven by on my way out of town every time I left Weber by his office. It's on the main street here as you head south. And I finally got it together and contacted and asked if he'd come and speak to us because in all my classes, including this one of the major things people say that they're interested in when I ask you at the beginning of class, one of the major things is intellectual property law. So patents, trademarks, right? It's really closely related to entrepreneurship, which is another way sometimes students could frame it. And I can tell you what the textbook says about intellectual property, but the truth is I don't know much beyond that. Devin does. So we're lucky to have him here as someone who practices in this area, has himself invented things and patented them, has helped many other people and small businesses as they move forward, right, protecting their property and trying to develop business. So I think it's going to be really beneficial to you. With that introduction, I'll let him take it away. We'll go from there.
Awesome.
And then here's the slides. You just have to use the arrows here. Go back and forth.
Nice to meet everybody. So I wasn't quite sure. I whether it's good, bad, or indifferent, I went to BYU. So I wasn't sure what the rules were for hats. When I went to BYU, they didn't let you wear hats. Like, this is my normal work attire. So I just showed up how I normally do in the office. But looks like it's at least reasonably acceptable.
I think we could have gotten an exemption.
Now they let you have facial hair. I couldn't have even had the facial hair when I was in school. So. All right, so so I got some slides. I'll kind of walk through and give you guys a walkthrough on that, a little bit about, first of all, who I am, a little bit about what being an attorney is, and then dive a bit more into intellectual property. I intend this to be a pretty conversational discussion. So if you have questions, you want to stop at any point or go through things, go in a different direction, has something you always wondered about, by all means, feel free to jump in. You don't need to wait till the end or at any given section. But kind of with that, a little bit, every attorney has their legal disclaimer. So this is mine. It basically just says, if you have questions, go talk to an attorney. Don't take this as the exact situation or covers exact situation that you may have. So you can read through that if you really want to. Otherwise, that's my obligatory legal disclaimer. That don't take anything I say is their actual legal advice. So with that, I would put myself probably as a non-traditional attorney. So certainly do more traditional legal work within intellectual property, but kind of give you an idea of maybe what a traditional attorney would look like as far as if you were to go into law versus kind of the way that I've set up my firm as well as my practice of law. So traditional attorney, ones I know, or this would be pretty well across the board, or even more specifically in intellectual property. You're usually working about a 10 to 12 hour day. Most attorneys, so they work by the billable hour. Billable hour means you bill a client for the number of hours you work. Firms have a requirement. It's usually somewhere between 1,850 hours to 2,000 hours a year. That equates to about 10 to 12 hours a day, 5 to 6 days a week. So you work a lot of hours. Most attorneys, as opposed to what you see on television, they're gonna specialize in one area of law. So that can be divorce, it can be bankruptcy, criminal, IP, whatever. Most attorneys, the only ones that you'll see that are kind of just general practice or more solo attorneys that are opening up a practice, trying to get whatever work they can come in. But as you get farther into your career, vast majority of the time is specialized. Couple other things with traditional attorneys, typically they like the practice of law, hate the practice of business. Meaning they don't really like to manage a business. They don't like to worry about the money coming in. They don't like doing marketing. They don't like doing sales. They just want to go practice law. The vast majority of attorneys are alcoholics. So if you were to look at it is one of the careers that has the highest alcoholism rate. It's usually they're dealing with the demands of pressure, clients, deadlines, everything else. Probably one of the highest or industries or highest careers that has an issue with alcoholism. And the typical attorney is married to their job, meaning they spend a lot more time with at the office doing the job than they do anything else. A little bit about now myself. As I said, I'm probably a little bit on the atypical side as far as non-traditional. So I have 4 kids. Oldest is my son, 14, 3 girls after that, ranging down to 9. I don't know if I like to run. I run a lot. I usually run around 20 to 24 miles in the morning before I get into or go to work. So that usually equates about 3.5, 4 hours a day, about 120 to 140 miles a week. I ended up getting 4 degrees. So electrical engineering, Chinese, an MBA, as well as a law degree. Favorite book is Atlas Shrugged. Capitalist book. If you don't like capitalism, don't read that book. Favorite movie is Forrest Gump. And as your professor mentioned, I have done a number of things. So I kind of have a split passion for startups and small businesses, doing the business side of things. I also like the legal side. So you can see there a few of the startups that I've done. Obviously, I started Miller IP Law about 6 years ago. I've been an attorney for about 11 years. So started the law firm. With the law firm, we do both a podcast as well as a webinar series. So I run that and manage that. Have a small or custom LDS gifts product or gifts business that I run with my kids. We've been doing that for 5 years now, and heavily my kids tend to manage and run most of that business, and I manage it with them. Also with my kids, do a food truck. So we do that. It's in the winter, it is build your own hot chocolate. During the summer, it is build your own or popcorn. Probably the biggest company that I've done as far as startups was actually one that I started in MBA school. So I guess MBA or law. So I did both the undergraduate as well as graduate degrees simultaneously. So I did 2 degrees each time. But with that, when I was doing the JD MBA, so kind of paint a picture, I was doing the 2 degrees. I was working about 20 hours as a law clerk a week. I'd had a 2-year-old son and a newborn. Amidst all that, I decided why not start business. So with that, the way that it actually got going was I saw a flyer. I think it was a flyer and email around campus. It was kind of one of those, hey, get together for a competition. It'll be, or you'll get people from different degrees and different areas on campus. You'll form a group. You'll enter into the competition. So I showed up, said, hey, that sounds like fun. Let's try it. Formed a group with 3 other people didn't know beforehand. And first year we entered in the competition. We took second. It was for a product to make gym bags less smelly. Didn't really go anywhere, but we took second. Came around the second year, we decided to get back together and enter into the same competition again. The next year, we're up juniors at that time, or in our 3rd year. Everybody had 1 more year. So we were kind of brainstorming some ideas, everything from or self-packaging boxes to a whole bunch of other stupid ideas that wouldn't have worked. But during that time, I had gotten into a bit more of marathon running. So I ran my first marathon, made the classic mistake, didn't hydrate well enough, got dehydrated, made the marathon more painful. So I had the idea of, hey, wouldn't it be cool if you could monitor your hydration? So you can make sure you're hydrated beforehand as well as while you're running. So that was kind of the genesis of that idea. built up or came home. My dad was in the medical industry. He also has electrical engineering background. Built up a prototype of it over the winter break. Tested it out. Entered in the competition. Took second again. I'm still slightly bitter about it. I'll give you the reason why I'm bitter is the people that took first didn't have a better product. It was the same people that had entered in the previous year that took first place. They just made their product better by or investing the money they won in the competition. So they didn't really do anything new. So I'm slightly bitter. We should have won first. But with all that said, took second. I bought out all of the other people that were in the competition. I took my second place winning, said, hey, you guys divvied up. I'll take the business because we're all graduating, going different places. Roll time forward. We built that up over the period of 6-7 years. Had investors come on, had prototypes. We were at one point working with a number of the colleges to test it out. Ended up merging with another company that was doing diabetes monitoring. A lot of the technology overlap. Merged with them, stayed on for a couple of years, and then about a year ago, made an exit with that business, sold out my ownership. So that one is a more recent exit. A couple other businesses do a lead generation platform. Started out as an internal software platform for the law firm to do lead generation marketing. Expanded out to offer to other businesses. The last one is probably more of a hobby. More recently, built a house where, so I live in Mountain Green. This is just up Weaver Canyon. We have about 19 acres. My goal is to plant 100 trees. No idea how to make that a business, but it sounds like fun. That's a little bit, is a really quick walkthrough about myself, a little bit about kind of what the traditional attorney is, about myself, where I kind of get into IP. Any questions about me, myself, things that I can clarify? Okay, no questions, we'll keep it going. A little bit more, so kind of, and I'm not gonna talk through all of these, but I get asked more what is kind of the typical day for myself as far as running a law firm or doing that. The typical day, I don't know that I have a typical day. I would say I have more typical activities I do throughout the day, but my day varies. What I do on a day-to-day basis varies quite a bit. Respond to a lot of emails, talk to a lot of clients, do podcasts, do IP work, do all the business side of the different businesses, client meetings. Those are kind of some of the typical activities I tend to do. Some days are much more weighted heavily on one area or another. That would be kind of if you're going to run your own practice of law, you're going to be more you're going to have a lot more variety. If you're an attorney, you're really going to be more responding to emails, doing things. Last one, kind of just setting up the stage about myself. So for about first 5.5 years of my career, worked for a couple larger law firms, worked for clients including Amazon, Intel, Red Hat, or Google. When I set up Miller IP Law, shifted to kind of where I wanted to be practicing. I like to work with a lot more startups and small businesses. We'll get into a little bit. I brought some of their products along to pass around. But I like to work with the startups and small businesses, get in more, give them a lot more feedback, direction, strategy, ideas. So the predominance of the clients that the Miller IP works with can be garage inventors, startups, solo inventors, side hustles, small businesses. As I mentioned, I'll also have a number of inventions I've done. Those are also clients of my own firm. Okay, before we get going on intellectual property, any other questions? I guess any questions, or has it been other questions? Okay. Oh, go ahead.
When is your next marathon?
Good question. So I did one this last August. So I did one about a month and a half ago. It was up at East Canyon. So my goal with any marathon is to get under 4 hours. So that was I got, I think, 3:45, 3:47, somewhere right in there. I usually try and do one about every year to 2 years. So I might try and do one next year. My son keeps telling me I should do an ultra marathon, which is about 30 miles. I haven't quite built myself up to be that motivated yet. So we'll see.
How do you not get burnt out? I feel like you have a lot going on.
Yeah. It's a good question. I mean, so I would admit, or I do well sometimes at balancing, and sometimes I get skewed probably on the side of doing too much business at the side of not doing as much with my family. So I think I've gotten a lot better. I think my wife would probably agree most of the time. But you know, where I came to or it works for me is, so when you're doing businesses, whether it's IP firm, you're doing business or anything else, the general thing that you tend to find is there's always tons of fires to put out. You always have more fires to put out than you have time during the day. And so it always feels like, you know, and you had that sense of urgency. So you always kind of want to push off, hey, I can do the family stuff tomorrow. I can do X, Y, and Z tomorrow. I got to get this done with the business. But or at least the philosophy that I came with is I put out as many fires as I can throughout the day. I walk away after a set given time, usually about 6:30, and I say, unless the building is burning down, I mean the business is burning down, I have to deal with it. The fires will wait till tomorrow. So I basically just get in the office. I work as hard as I can. I usually work through lunch or work through the whole day. Don't really take many breaks. And then at the end of the day, I just say everything will wait till tomorrow, and I have to unplug. That's about the best way I can find that balance. Beyond that, I don't have any better answer. Is there one other hand, or does that answer everybody's questions? Okay, well, always, as I said, feel free to ask questions as we go through. Jumping into a little bit of intellectual property. So if you're to kind of take a step back a little bit, when you think of property, most people think of more something that's real property, is tangible, something you can hold in your hand. So whether it's a land, whether it's a car, whether it's a house, whether it's, you know, a computer, whatever it is, that would be a real property. Easy to understand, it's tangible, you can grasp. When you're looking at a kind of what intellectual property is, there's an overlay to it, but there's a bit of a difference. It's those things that you can't grasp, you can't put your hands on, and yet still have value. So they still are an asset of the business. And if you think about it, you know, those are the things like, as an example, start a business, you're going to put in a ton of time and money and effort to come up with a new product, new invention, something that, you know, that is an improvement that you can go sell in the marketplace. Well, how do you capture the value of all that time, money, and effort? Because typically, once you put that on the marketplace, it's like the magic trick. Once everybody sees it, they know how it's done. It's much easier to reverse engineer or recreate. And so you put in all that time, money, and effort, you put it out in the marketplace, everyone says, oh, that's an awesome idea. Now I'm just going to go copy it. I'll put a competing product. I don't have to invest that time, money, and effort. You lost out on all that. Disincentivize people. Same thing with the brand. You take all the money, time, and effort, you marketing, sales, you go out there, you do all the trade shows, you do the events, online, put out content, you make a great brand, and somebody says, hey, I love that brand. I'm just going to ride their coattails. I'm going to mimic it. How do you capture the value of all the effort it takes to build a brand? Or you write the next Harry Potter, Tom Clancy, Lord of the Rings, choose your book or genre, all that time and effort to write the book, culmination. Somebody says, great, I'm just going to copy, you know, download the book, copy and paste it, and I'll put out my own version of it, make money off of it. So when you look at it, intellectual property is really giving avenue for capturing that value for what is the intangible aspects that still require a lot of investment, time and effort, and yet aren't necessarily tangible, but are valuable to the business. So if you look at intellectual property, it's really kind of an umbrella term that captures three things: the patents, trademarks, copyrights. So I'll throw it out there. Who can tell me the difference between what a patent and trademark or copyright is? High level, just as a general overview. Anybody have any ideas?
Don't patents protect your inventions? So patents are inventions, trademarks are your like symbol for your brand, and then copyrights is like the right to your own work.
Yeah, that'd be a pretty good overview. So patents are inventions, trademarks are brands, copyrights are creatives. Really, if it falls into one of those three categories, intellectual property covers it, and that's what uses the avenues to capture that value. So that's a great overview. So we'll start out with patents. Typically, when you're looking at patents, there is a couple things to think about. One is people typically have a wrong impression of what patents do. Patents don't give you the ability to or sell something out in the marketplace. They don't mean that you own it. What it does is it gives you a shield that if somebody else comes along and uses your product or uses what you patented, you can have an avenue to stop. So it's not a positive, government's going to make you sure you can sell this or be successful. Rather, it's a shield that if people can't come along, copy, mimic what you've done without your permission. So patents really going to go towards an invention as a functionality. It does something. It has a utility. There is a subset of patents that are also design patents. That is going to be something that has an aesthetic nature to it, a look, a feel to it. So if you think as an example, take the iPhone, they have both design patents, they also have utility patents. Utility would cover the touch screen, the antenna, the battery, how it all works, all those functionalities. The design patent, they moved away from the design, but used to be the curved edges, circle at the bottom, that would have been a design patent. Samsung and Apple got into lots of patent wars with regards to the design of who owns what kind of aspects of the design. So with patents, walking through, not going to go in depth on the process, but to kind of give you an idea, what are kind of walking through the steps of how you would go about getting a patent. So first of all is coming up with an idea. I would say this is contrary to probably a lot of where people come. Ideas are actually probably the easiest part of starting the business. Not that it doesn't require a lot of effort, but I'll say there's a lot of times I'll get on a client call, talk with the clients, and the first words that they'll come out is, I've got a great idea. And that's usually the indication of we're way too early on in the conversation, because ideas are easy. Everybody has not everybody, I should prevent. A lot of people have great ideas. Building a business is now the execution of that idea, meaning nobody is, or almost nobody is going to pay you for the idea. So the kind of, a lot of times people think, hey, I'll have a great idea. I'll go get a patent. I'll license, or everybody will be knocking down my doors to pay me for it, get a license, and I'll simply go retire because I had an idea that I got a patent on. 99.9% of the time, that's not true. I'm sure there is somebody that had a great idea, went out, got a license on it, but the vast majority of the time, a patent is an aspect of the business that helps you to protect it. It's not the business itself. In other words, you don't just have an idea, get a patent, and then you're going to make lots of money. You have to build the actual business around whatever the invention is. But the first thing is to come up with the idea. Misnomer, you can't patent an idea. So in other words, if all I were to say is, and I've had various ones, probably my favorites are always when you get the people that come and pitch you for the perpetual motion machine. So I probably had 10 to 15 people over my career that have a variation of basically perpetual motion. Don't know what a perpetual motion machine basically makes free energy. It's a device that makes more energy than what you put into it. Goes against the laws of physics. Patent office has gone so far. There are really two areas where the patent office said something is just absolutely blatantly not patent because they had enough patents, or people trying to get patents that they're just never proved out. One is a cure for cancer. You can patent how you go about treating cancer, but at least until you cure cancer, I am sure the patent office will make an exception for you. But they've simply said, as of now, there aren't any cures for cancer to simply solve the cancer problem. Quit filing patents. You can't file them, automatic rejection. Other one is a perpetual motion. Again, if you solve that problem, if you make a perpetual motion machine, I'll do it for free and I'll file it for you. But you're going to have to show that it actually works, which is usually the conversation. Somebody will say, got an idea, makes free energy, makes more than this is. Okay, have you actually built it? Well, no, but I know it will work. I figured it out. Then why don't you go out, you build a prototype, come back, we'll talk about it. Those people never get past the idea stage. You can't patent an idea. Now you can patent the implementation of the idea. So how you actually go about making it. So that's kind of that step of when you're in the idea development, you have to have enough details of how it would work. To go after a patent, it can't simply be, hey, I want to cure cancer. I want to make a perpetual motion machine. It has to be what you're patenting is the details of the implementation. So oftentimes, once you have the idea, once you get the details of the invention, you can do a patent search. You don't have to. It's not legal or required. Patent office will do their own version of a search. Oftentimes, you'll have an attorney do that first because the attorney is going to go out and they're going to look at basically 3 standards for patent. I know it's up here, but it's anybody idea. If you were sitting there setting up, let's go back to the 1700s when they very first set up the patent system in the US. There's other ones earlier than that. How would you go? What would be the ways that you determine whether or not something is patentable? Anybody have any ideas? If you were to, or commissioned by the government to set up the patent system, how would you go about determining whether or not you think that the government should grant a patent? Thoughts or ideas on how you would set up that patentable standard?
It's new, like no one else has done it before.
Okay. Novelty. Okay, other ideas. What other, that'd be a good one. Other words, you don't want to get, if everybody's creating the same ideas, what's already out there, it doesn't incentivize anybody to make something new. You're just going to have block.
If it's useful to society to make life easier, better.
Yeah. Usefulness is, I think, is a good standard. How would you go about defining it? There's a lot of useless things that are still patented that people buy that are probably there. Now, if you're to go to Europe, has more of that standard. So Europe has more of a almost a functionality requirement. US, not as much. It doesn't have to be useful. It does have to be new, has to be, or can't be previously invented. If you want to go out and create something that really doesn't do, but think about the Snuggie. Now, Snuggies may be awesome. You probably, I don't know if they're up to the level of usefulness, and yet you could still probably, I think they got a patent on it. It may have been invalidated. I have to go look, but they originally had a patent. But usefulness, I think, it is almost, I would say it's more utility or functional. In other words, it has to do something. In the US, doesn't have to be useful. I get that it may be a good standard. Any other thoughts on standards you may put? Okay, well, a couple of the other ones, when they originally set up the system that they came up with, was non-obvious. So non-obvious kind of goes along with novelty. So one is nobody else has previously invented it. Second standard is you can't simply go out and combine two things that are already previously out there. Meaning if all I did was say I took a pencil and I took an eraser, the old or rectangular eraser, and I crammed it on the top. So I said, hey, I've combined a pencil and eraser. Simple example, but they're going to say that's an obvious combination. All you did was take the pencil, you crammed it on the top. You can't get a patent on that. Vice versa, when the original pencil, original pencil, the number 2 has a little eraser on the top, has a metal crimp. That was actually originally patented. And the reason that was patented is it wasn't just cramming on the top. It was an obvious combination that you put the eraser that's the same size as the pencil. You may have the metal grip that combines them together, makes it a unitary product. It actually overcomes obviousness. So the second one is you can't just simply take 2 or more things out in the marketplace, throw them together, try and call it new. It has to have a level of uniqueness or a level of differentiation of inventiveness. Third one is abstraction. I hate abstraction. It's a terrible standard. The Supreme Court always messes it up, but nonetheless, we get to deal with it. Abstraction at its fundamental level basically means you can't patent a mental process. Something that you could do in your head, do on pencil or paper, generally is mostly applicable to software patents. The idea is, hey, let's say you took 2 + 2 = 4. You have to be the first person to put it on a smartphone or on a device. You just simply can't patent math because you have to put it on an electronic device. That's kind of the idea. Now, the reason that it's really hard is in the Supreme Court, every time they touch patents, tend to mess it up, patent law. But it is really hard to define what is a mental process. So a lot of times when you get into software, technically, given enough time and effort, millions of years, human could probably do just about everything software could, given enough time and effort, enough people getting together. In reality, you're going to have to actually be able to implement it. There's an advantage of putting it on an electronic device. So when you get into abstraction, you have to show why it's not, or what the types of technology is, why it's an improvement, how it makes the technology better, how it can simply be done by a human in their head or on pen and paper, but how is actually an improvement in technology. So you do that, go out, you do a patent search on that, or you skip that step and you just go directly to patent. Patent office will do that same type of examination, which we'll get to. Third step is prepare and file the application. Can't do that yourself. There isn't a requirement that you have to use an attorney. A lot of benefit to using an attorney because generally, if you don't, or counterintuitive is, as an example, if you use the word invention wrong in your patent, in the patent. Because if you say my invention is, and then you write it out, that's the only thing your invention covers. No variations, no differences, limits your scope significantly. So if you do it yourself, you do it wrong, it can devalue the patent, but you can do it as a individual, or a lot of times you'll go hire an attorney. File the patent, you get a wait, and hence the picture. Typically, once you file a patent, you get a wait in line for about 12 to 18 months before the patent office will even start looking at your patent. So you'll be patent pending, you'll have your date of invention, and then you get a wait about 12 to 18 months. At the end of that wait, you'll have an examiner, will pick up the patent, they will look at it, say, does it meet the 3 standards for patentability? Novelty, obviousness, abstraction. Generally, you're going to get a rejection. Usually the typical patent, 1 to 2 rounds of rejection, where they're basically going to come and say, doesn't meet the standards for patentability. Here's the previous inventions that are out there. And then you get to argue with the examiner why your invention's different, what's unique about it. You'll have an interview. Usually it's either by phone or by Zoom, or I guess they use Teams, which I don't like, but they use Teams, where you'll talk to the examiner, explain the differences. You'll go back and forth as to the scope of what your patent covers and what it doesn't cover. Usually go about 1 to 2 rounds with the examiner, and then you'll either, at some point you'll give up and say, okay, not going to make progress with the examiner, or vice versa. The examiner will finally grant your patent. It'll be issued as a patent, and then you'll get to pay the government the pleasure of paying the fees of years 3.5, 7.5, and 11.5 to keep your patent active for a total of 20 years. That's the quick run through and overview of the process of getting a patent. Any questions on kind of at a high level?
What happens if you don't pay the fees after?
You lose your patent. So in other words, I'm not justifying it other than the patent office is the only part or branch of the government that actually makes money. So that's their one positive, I guess, but the way that they make money is through all their fees. Now, the sad thing is the government then takes all the money the patent office makes and funnels it over to all the other areas that don't make money. So the patent office never gets to reinvest it. In order to keep your patent active, part of that is you pay those fees. If you don't, and it happens, you'll get to, let's say 11.5 years, and sometimes as a business, you'll say, hey, this invention is no longer worthwhile. We're no longer making money off of it. We could keep it active, but it doesn't make sense to pay the fees anymore, and they let it go down. As an example, or you go out of business, or you pay the fee because it's still worthwhile, but you have to pay those fees, otherwise the patent is going to abandon at that point.
How high are the fees? Does it depend, or is it like always?
So it gets incrementally more expensive, and it also depends on what size of what they call entity status you are with the patent office. So patent office breaks down their fees based on if you're what's called a micro entity, small entity, large entity. Micro entity basically means is the inventor or is an owner of the patent applicant. You've done less than 4 patents in your name, and annually you make about less than 208,000. It varies a little bit. They said it as a multiple of poverty. You're at a micro entity. Fees are usually about 1,000 for the first or 3.5 years, 2,000 second 7.5 years. Third maintenance fee is about 3,000, 2,000, 3,000. It doubles as you step up for each entity size. So if you're not micro entity, most of the time you're a small entity. The only time you're a large entity is if you're a huge business, have more than 500 employees, and the vast majority of businesses don't. Even if you're a pretty sizable business, you don't have more than 500 employees. So then you take that micro or small entity, double it, so 2,000, 4,000, 6,000, or 6,000. Large entity, double it again.
If you had 2 people and they both had the same idea for an invention, and let's say they would both pass for the standards of patentability, would it just be the first person to file a patent application that would get that idea?
So what are you saying today, or what point in, because it varies, and so when would, in the hypothetical question, what year am I in?
A year? Let's say 2 years ago.
All right, so 2 years ago. Okay, so 2013 is the differentiating period. Before 2013, US was under what's called a first to invent system. Basically, as long as you could show that you were the first inventor, even if you filed later on, if you could go back and show, here's my invention history, here's when I came up with it, you had to meet a good burden of proof, but you could actually come along and file it after and be able to still get a patent before or after somebody had already filed for patent. US was unique in that, and most of the rest of the world was called a first to file system, which is what the US now is. 2013 came along, US said, okay, we're going to join the standard for what the rest of the world is, which is a first to file system. So hence why I asked, before 2013, it would have been whoever invented or could prove they invented it first was the one that could get the patent. After 2013, it's whoever really files on it. Rare exception, if you could prove like you had an employee that stole the invention, went out and filed their own patent, you can walk that back. You can, if you're the business, they should have, or it should have been the business as an employee stole it. You could still file it for it after and get it, but 99% of the time, whoever filed on it. Now you always get the person that says ones if they file it are both on the same day. Technically, they could look at, they treat the same day as the same day. So in other words, if I filed it 1 minute before the other, generally then you have to go through a process of showing who invented it first. But that is a less than 1% of the time, very rarely happens that somebody has the exact, without or somebody doing wrong on one side or the other stealing it, the likelihood of someone come up with the exact same invention on the same day, filing it the same day is a fairly rare exception, but there is a process.
If there was like an employee that had an idea at a company and then like they leave that company and then pursue the idea, but they like say like told their boss about it or whatever, would the company still be able to like try to fight that?
This question, I get a question from the clients a lot. You'll get the standard lawyer answer, which is it depends. Now, the factors that you look at it. So one is you look at your employment contract. First of all, are you an employee versus an independent contractor? Two separate. Independent contractors or freelancers, they do it as on a project by project basis. They're not employees of the business. Employees are just, 1099, you get your paycheck, we hire you. So they have different types of contracts. Usually both of them are pretty well written that they'll cover it. But most of the time, employers, unless you're just a really small business and not very astute or, very experienced, most of the time is pretty well covered in an employment contract as to who owns it. Employers will generally say anything that you created, whatsoever, employment contract will say, whatever you create during your time you're hired with us, we basically own your money. Not quite the case. The true factors where the law actually comes in is they look at what or how you invented it. So one, did you use any company resources? If you use any company resource, that could be the computer, it can be doing it in your office, it can be using software or product or their devices or anything else. You use the company resources, generally they own it. So if you wanted to do something outside of the business, do it on your own or time and dime, don't use any company resources. Second thing to look at is, did it leverage or utilize anything within the business? Knowledge. So is it something that you had proprietary knowledge that you use for the business? Was it something that you got trained with the business? Did you leverage any of that information or knowledge that came about because of your employment? If you did, they generally own it. If it's something outside of the business, generally you would own it. So those are usually the two main. There are some other factors as you get more nitty gritty into, but generally you come up with it on your own. You do it on your own time and dime, and you don't utilize any of the business resources or things that you'd have or special knowledge of because of your employment. You typically own it. If you do any of those factors, typically their companies can own it. Now, there are a lot of times where the business or some businesses will be favorable, meaning that they want their employees to own it, they want their employees to be incentivized, and so they'll have different rules where, hey, you come to us, you pitch us the idea, we turn it down, you own it, or we'll give it to, we'll get a percentage of revenue that's generated, but you own the predominance of it. But there's a lot of companies had a discussion with an employee. They used to work for Amazon, or a client. They used to work for Amazon. Their question was, is something well outside of it. They came up with it. It's a little. I won't get into the details because it's still confidential. But it was outside of anything they did with Amazon. They didn't use any of the resources. They were fine. But Amazon you look at their employment contract, it is really aggressive on what they say they own. They basically say anything you came up with during our employee, and really any time within your lifetime, we're gonna try and own. So work for Amazon, you'll get an extra little hurdle. But generally, that's kind of how they think about it. Any other questions on patents? Go ahead.
Why specifically that year segmentation for patent payments?
Did I say one more time?
Why specifically that year segmentation for patent payments? So 3.5 cents.
I don't know that I've ever looked at that question. It's a good question. The short answer is I don't know. I mean, what they're at a general level, I don't know why they came up with 3, 7.5, and 11. Typical patent is 20 years, so they're probably looking at it says, hey, it takes 2 to 2.5 years to get a patent. So, and then another 3 years, you're 5 years, go another, or 4 years, you're 9 years, 11 years, and they're saying we're going to try and spread it out. So if you're wanting to keep your patent active and enforceable, we're going to kind of make you do it throughout the general life of the patent. As you get towards the end, we will. Incrementally, the reason it gets more expensive is they want to put a penalty, but they want you to actually look and analyze. Do we want to keep an exclusivity? Do we want to actually keep this off the marketplace? If you do, you have to continue to pay more the longer it gets into it. The trade-off with the patent is they're trying to incentivize, hey, you go out, you invent something. When you do a patent, you tell the world exactly how it works, what it is, and how it goes. The trade-off is you get that exclusivity. The end of that exclusivity, anybody can do it. It's out in the public domain. So they're trying to balance getting people to have exclusivity to invest in inventions, having that in their exclusivity, while also giving something in a public domain to generally motivate other businesses to leverage what's out there. But specific periods, I couldn't tell you. It's a good question. I'll have to look it up. Go ahead.
I saw a little bit ago about how Volvo created the 3-point harness, and then they left the patent open so other car manufacturers could do that. If they had decided to keep it closed, could the government later on revoke the patent so others could do it for public safety?
Probably not. I mean, the government they're trying to make whatever rules they want. The only area that government can largely step in, I've only had, I think, 1 or 2 cases in my career that has come up, is with regards to their safety, and that's usually with regards to weapons. So if it is something that's, as an example, I had a client, they didn't end up they got an initial notice that they might qualify under this, and then it ended up they didn't have to worry about it. It was to do with nuclear stuff, and they're saying that's public and national security and safety. If it gets into that area, the government can sometimes step in. You still own it, but the government basically puts a lot of restrictions on confidentiality. They can also basically say, we get access to it, we don't have to pay you for it. We are almost a co-owner of it. Aside from that, generally the government isn't able to step in or otherwise take over your patent. Except now along those lines, you have to look at it a lot of times. There's a couple of companies that are kind of, hey, we'll open up our patents to the world and let anybody use them. Tesla is a pretty big one. And Red Hat, which is Linux or one of the other operating systems, another one. Most of the time they still have huge, so I did a lot of Red Hat patents earlier on in my career. Their position is we still aggressively pursue after patents, because if somebody else comes after us, we're going to be basically mutually assured destruction. Meaning we're not going to go out and actively enforce patents against other people. Their perspective is we want to encourage innovation, but if somebody comes after and starts suing us, we're going to unleash our patents on them. So generally, when you look at that, it's not just a free for all. They still have rules as to how you can use their patents. But there are some companies that will take that approach, but that's usually internal, company by company basis. Government, aside from national security and defense type of things, they usually can't step down. Good.
Would you say that the chances of getting a patent on software are really low?
Depends on when you do it. So if you ask me, so it's a pendulum. You kind of 2 factors. One is Supreme Court steps in, they usually mess things up and make it less clear as to what is patentable with software. So if you were to go back several years ago, they had a horrible, my personal opinion, they did a couple of cases that really made it unclear as to what abstract and what is patentable with software. So that's when the pendulum to make it harder. Then usually it swings back in because they say, well, we don't want to stop the whole or software industry, huge part of the economy. And so they'll start to figure out what the or how to implement what the Supreme Court did. The other thing is it does to do it to a degree of who's running the patent office. So they will do internal trainings within the patent office. They'll go out and basically say, examiners, this is how we want you to take the perspective of when you're examining something that's software related. When you get those trainings, they'll either open it up and they'll make it easier to get a software patent, or the trainings, depending on who's the one that's running the patent office, will make it more hard. So 2 years ago, you were kind of on the pendulum of it was easier to get software patents. Right now, it's kind of swung more over to it's more difficult. Always there's possible, still have clients day to day file patents that are in software related, but you have to be a lot more methodical, very meticulous on how you show the tie to technology, the improvement, meeting within those categories. So right now, it's probably at a harder level to get a software patent. But if I were to file today, I'd probably say, given that you're 12 to 18 months, by the time they actually pick up your patent for looking at it, my guess is the pendulum will probably be kind of somewhere. So you can get it. This really depends on how much the Supreme Court messes things up and who's over running the patent office and doing the internal trainings. Does that make sense?
Yeah, thank you. What part of this process are you most heavily involved with?
Steps 2 through 5. So in other words, we do patent searches. You know, those aren't legally required. So I'd say about half of our clients will do a search. I always encourage them. They give you an idea as to whether or not this is previously invented. It also gives you an idea as to where to focus your patent on. So let's say you have an invention, 3 or 4 features that you think are innovative, and you go out and do a search, say, hey, really 2 of these are pretty well covered in the market or with other patents. Let's focus on those other 2. So we'll do about half the time, do a search for clients. The other time they either feel confident what they've invented and they don't want to spend the money, or they simply don't have the budget for them. So we'll do patent searches, preparing and filing the patent application. That one's pretty mainstay. That's what we do quite a bit of the time. And then you'll get into the review and examination process. That's probably about half the battle with the patent. So first half is setting up a good patent that will actually cover the invention, has a good chance of getting through and checks all the boxes. And then you're gonna, no matter how good a patent, about a third of the time with our firm, it'll go straight through, meaning you don't have any rejections. Goes right to patentability. That means about 2/3 of the time you're gonna get back and forth with the examiner. So generally we'll do searches, file the patent, argue with the patent office. Technically, we do maintenance fees. We'll pay those for the clients, but that's honestly just paying a bill for or managing the deadlines and paying the bill for the client.
Are the examiners like specialized in certain fields, or do they just handle like everything?
They are most of the time very specialized. So usually they're not usually attorneys, although a lot of times examiners will become attorneys because they'll look at it and say, I can make about 2 to 3 times more as an attorney than I can as an examiner. So they'll stay at the patent office for about 2 to 3 years and then they go out and become an attorney because they want to make more money. But they're usually either masters or PhDs within that given field. Patent office is pretty narrow categories, and so usually, with exceptions, sometimes you'll just get an attorney or an examiner that's just terrible and doesn't understand things. Vast majority of the time, they're usually pretty smart. They do this or specialize in a given field. The other thing that you'll note is with patents, a lot of times, depending on which area you get in, you'll also have a big difference in the queue as far as waiting period. So if you get in a area that is very backlogged, lots of inventions, lots of patents, AI is an example right now, you get to wait about 3 years before they'll start looking at it because the number of examiners that are qualified versus the number of patents makes for a long waiting time. But if you're in a different area, let's say refrigeration, that one's the one where we usually get that in less than a year. But they will be usually PhDs. About half the time they're going to be immigrating into the US. In other words, they were foreign born. And so there's sometimes a language barrier just because English isn't their first language. But they're once you get beyond that, they're usually pretty specialized and have a pretty good background. Okay, any other questions on patents before we kind of go to trademarks and copyrights? I'll pass around. These are just for fun. A few of the products by our clients at Miller IP, these are all patented or patent pending or patented products. Some of them are still in process. One is a spoon. If you'll notice, the tip is flexible. It's for scooping. That makes it a little bit more. So it has a hard core, and then at the very tip, it doesn't. That one's for writing gloves. Basically, it allows for more sensitivity. The way that they put the stitching on the top of it, basically, to somebody that was a poor writer up in the attic, they got tired of their hands getting cold. They tried to wear normal gloves. Gloves didn't allow for them to type very well, so they came up with that. This one is a kind of it's a prototype, but it is basically almost a switchblade that is for divot fixing with golfing. And this one came out with COVID, which was a wristband hand. That one is it's more on the trademarks and branding. So you can pass those around, look at them. Go ahead.
Those patents, like that switchblade you just mentioned, they like build off of another invention if you like make a new way of it.
Yeah. So the example I always give is, so let's say, and it was in reality, you came up with the color television. Color television generally is going to build off of the black and white television. So the way it would work is whoever was built the black and white television, they went out and got a patent on it. When you come and say, hey, I've got a great idea to make black and white television, color television. Really, it takes everything that's on the color television, builds on top of it. You can get patents for each. So the person that has black and white television, they have a patent on theirs, gives them the ability to have exclusivity. When you get now the color television, the problem is it builds on top of the black and white. So while you have the patent for color, you can't go make your product because somebody already has the patent for the underlying fundamental black and white television. Vice versa, the person that has the black and white television can't go make color television because you have the patent for that. So it kind of forces people to collaborate, license, to otherwise work together. But you can go out and you can take something that's an underlying invention, build on top of it, improve it, make it better, and get a patent for it. The thing you have to look at is whether or not, if there's an underlying patent, just because you get a patent on it doesn't mean you can make a product, because somebody may have the patent for the underlying aspect. So does that make sense? Go ahead. Go ahead.
What if, I don't know, I file for a patent here and they say, no chance, can I go to a different country and try it again? Or do
Technically,
people like?
I mean, you
does the-
can, I mean, so most of the patent offices throughout the world. So yes, you could technically go out and, there's some deadlines, periods within which you have to file them. Biggest one is public disclosure. Once you put it out in the public, where almost all countries, you have a year to file a patent on. Miss that window, you now donate it to the public. Let's say you did it within that year. So theoretically, you filed a patent, you said, okay, patent office is going to reject, US patent office is going to reject it. I go file it in the EU. All of EU is a lot harder to get a patent in. We did that. They're going to generally look and see what the other office is. So they have a collaborative ability to access each other's databases, see what the patent is or examination process that took place in the other countries. So if, let's say you filed it in the EU, they're going to go and say, hey, looks like this was also filed in the US. What did the examiner do there? And so they are going to do their own determination, but generally they're going to look at the US, and if it got rejected in the US, it's going to make it a lot harder to convince them that the US was wrong, or vice versa if it was in the EU. So you could, but your likelihood of getting it in one country and not in another is going to be more difficult, unless you go to some countries are easier. China's easier to get a patent in, maybe a little bit harder to enforce it. But you could have some of them that have a lot lower standards. You might be able to. There's one other question.
Yeah, I was wondering, can you file a patent before the product is made?
Yeah, all the time. Most companies do. So generally, most people, whether startups, small business or large businesses, you're going to be filing patents on products that you haven't even prototyped out yet. In other words, as long as you can, the standard for whether or not you can file a patent or pursue one is what you can do. Is called conceptual reduction of practice. What that basically means is that you have to be able to explain it in a level of detail that somebody else in the industry, given enough time, money, and effort, would be able to go out and invent or create the invention. So if you can explain it to that level of detail, you don't have to have a prototype showing that it actually works. You don't have to be out in the marketplace. You just simply have to do it to that level. So a lot of times with businesses, they're going to be looking at it. When I did as an example with Amazon, they would file a significant amount of patents on or features that they may or may not at some point include in their products, but they wanted to make sure that if they went down that route, that they would be able to have exclusivity to it. So they would be filing a significant amount of patents that never come about. You'll see that with Apple every so often in the news. It'll say Apple filed a patent for this cool or crazy invention that is or sounds awesome. You never see it hit the marketplace because they're pursuing a lot of different inventions that may or may not come. Okay, give a little bit of time just to hit on the other couple of things. So the next one, we'll just jump over to copyrights. So it's as we mentioned a bit before, copyrights are going to be something that's they're creative in nature. So generally, if you look at, it's going to be writing, so books, poems, anything that's in writing, artwork, music, podcasts, sculptures, movies, all of that falls under copyrights. So it's going to be the thing that you capture that's more on the creative side. So patents or inventions, copyrights are going to fall under, or if anything that's creative in nature. So a couple things that are hit on. So one of the ones that this was about, or primarily about a year ago. So who has an idea as to how long copyrights last?
Isn't it 70 or like it's the creator's life and then 70 years after that?
Either 70 or 90, depending on if it's a anonymous person, meaning they don't know who created it, or if it's a individual. So 90 is typically if you have if you know who the individual is, 90 years plus the life of the author, or it can't be 70. So it depends on if it is a individual that filed for the copyright, or let's say later on the family came about and it wasn't the actual individual, it can be 70 to 90 years. So, and it also depends on if it's a corporation that owns it or not, but generally rule of thumb 70 or 90. But one of the things that you'll get into is eventually copyrights do expire. And so you have that pretty long life. The idea is that when you have it, life of the authors can say, hey, you created it, you came up with this for the extent that you created it, you should be able to profit of it and you should have ownership of it. And basically the thought is you get one more generation. So the people that are the kids or descendants of the person that created the work, they make money off of it. Afterwards, it becomes in public domain. Some of the ones that you're starting to see are now the earlier ones for Disney are starting to hit that. So if you're to look at it, there are some of them can get up to, depending on when it was filed, how it was done, it can be up to, I think it's 120 years. Disney keeps trying to push that out farther and farther. They have the incentive. They've created a lot of characters, a lot of iconic things. And for a while there, it was actually shorter than that. But every time that it was supposed to, or things were supposed to be coming out in the public domain, were supposed to set to expire, Disney would go or legislate in Congress, have them extend that out for another 20 or so years. And so that's moved the ball several times. So when you look at copyrights, if something expired, you have to be pretty judicious about when it was created, when it was copyrighted, as to how long it's out there. Some of the ones that are more recently, if you're to look at Disney, the earlier, so Steamboat Willie, which is the original Mickey Mouse, that one has now come out in the public domain. Winnie the Pooh has also come out in the public domain, and that's why you can see when you like R-rated, really gory movies that I haven't seen, you're starting to see those come out in the marketplace, which are I think Winnie the Pooh, there's now a number 2, I think, that's coming out. But it is basically the reason that they're doing that is Winnie the Pooh came out in the public domain about a year and a half ago. And so now that you basically had a genre of, hey, we're going to take iconic kids material, we're going to make it exactly opposite, make it as gory and as bloody as possible. And so you're starting to see that. The reason that you're starting to see those now is because the earlier Winnie the Pooh and Mickey the Mouse, Steamboat Willie are coming out as being available. Copyrights have expired. Now, the issue you have to be careful with is which version or variation of the Mickey the Mouse or Winnie the Pooh are you using. So if you're taking the same example of the top 2, and it's covered up by the video or the video, but would be you have early generations of Winnie the Pooh with the piglet, and Steamboat Willie, those have come out in the marketplace. You can use those for the copyrights. You take the two bottom ones, those ones are not available. So if you're to go out and you're gonna make Winnie the Pooh as it looks like there, or Mickey the Mouse, you're gonna be infringing their copyrights. So there is a iterative process. It's not simply just, hey, or Steamboat Willie, Mickey and Mouse is out there, free for all. Anybody can do anything with Mickey the Mouse. You can notice his ears are different, his nose are different versus the common one. They have copyrights along the way for each of those different variations. So if you're looking now, as an example, the movie, it much more looks like Steamboat Willie, doesn't look like his the current one. Winnie the Pooh, if you look at that, I don't know on the newer movie, because one of the characters, I'll put it out as trivia. Which character wasn't in the original Winnie the Pooh slasher? Anybody have any guess as to which character was absent? Eeyore? Wasn't Eeyore? No. Tigger. So Tigger came out about a year and a half after the original Winnie the Pooh. So when the original Winnie the Pooh slasher movie came out, Tigger wasn't in the public domain yet. They couldn't prove the character. I don't know if they've now, I know that there's a number 2 coming out. I don't know if he's now the number 2, but that would be kind of one thing. So there was that ability to you leverage that IP, those copyrights as it came out in the public domains, but you have to be careful. The other thing we'll get into a little bit, trademarks, you also have to be careful. So you notice on neither of these does it make any mention of Disney. Disney is their trademark. If they would have either of the movies, they would have put Disney on there. They'd have got themselves sued into oblivion because Disney didn't want it also at all be associated with slasher movies. They could stop people from using the Disney brand. They couldn't stop people from using the characters or the public domain.
With the Steamboat Mickey, could they use like this song, like the tune whistles?
Yep. So everything that was in the original Steamboat Willie now is in the public domain. That'd be the same if you look at, it used to be more so when you had CDs, but you'd have compilations, an example of all the classical music that was out there. They would be huge compilations and everybody would be selling. The reason that those were popular for a while, CDs, because all of those were expired. They didn't have to pay any royalties. They didn't have to pay anyone. So it would make it for a cheap CD that you could simply go out and do it. So yes, you could do the music. You can go and use a video. You could use the characters. Anything that's in there would be open to public domain. See any other hands? Okay. One of the other ones that is starting to get a lot of attention with the advent of AI and copyrights is how does AI play into copyright ownership? In other words, I go out and I use whether it's ChatGPT or choose your platform, have it create artwork, have it create an image, have it write a book, have it do anything else. Who owns it? The short answer is the courts don't know. And the reason is the courts are very slow to evolve. They are a very monolithic, slow-moving system that usually takes several years when anything out there comes out and disturbs the marketplace for the court system to catch up and really adapt to it. It takes quite a few years. Right now, it's early enough on that to a large extent, there's some things that are starting to come out, but the vast majority is you're going to be a bit in the Wild West as far as AI ownership. And the reason a lot of the issues with that are, as an example, who is the author? Who is the owner? If you simply tell a AI, and this one's an AI generated image for this copyright or for this presentation, I used ChatGPT, gave it a prompt, told it to create a image that was for AI copy or AI making art. That's what it gave. So now am I the author? Did I create it? Did I come up with it? Or did AI? AI came up with it, I gave it the prompt. Or is it the people in the back that created the algorithms, that created the software that trained it? It's still a bit of an unknown. Right now, they're tending to say whoever gave it the prompt, whoever told AI to do it is still the author because the original creator. But it's still not well defined. I'll get to your questions in a minute. The other question is going to be on originality. So generally, humans used to create their artwork. It was something that came out of their head. They may have taken inspiration, thoughts on what other people came up with. With the AI, AI doesn't have original thought. It can take a compilation of a lot of things that are out there, be trained on it, and still or come up with something that's in quotes new, but it's really taking a training or set of data that's trained on and creating something from that. So now, is it original? Does it make that original out originality requirement? Again, it's an unknown. So if you're to look and say whether AI is copyrightable, right now they're saying yes, it's copyrightable. People that are the original person that gave the prompt and created it should be the owner, but that could vary as the courts catch up to it. Like, there's a question.
I think the fourth point might answer the question. That's what it trains off of.
Yeah, and that one's another hard question because when you're training it off of the data set, how close of inspiration does it have to other works of art? So this would be whether or not it's human created or whether or not it is AI created. Is if I go out and take an image and I slightly modify it, do I have copyrights to it? Well, you can have copyrights to the modifications if it's original enough. In other words, if all you do is take something that was in color, make it black and white, probably not. But on the other hand, if you were to take, and it was, I think it was for Obama that they did kind of the 4 pictures, different colors, made it kind of a collage of different images of Obama. It was a painting done by an artist, not by AI. He owned that, or he didn't own the image of Obama, but he owned the originality of how he colored it, how he made it a collage and made it different. So same thing with the AI. The question is what is it using for inspiration for the data set for training? How closely does it mirror other copyrighted works that are otherwise out there? Short answer is I don't know. Or in other words, the courts haven't caught up to really decide, given that it is using other people's works as inspiration, how does that play into it? Right now, they've kind of punted it, or they haven't given a very good answer. Okay, other questions on copyright before we shift to trademarks? I'll walk through really quick. Copyrights are usually pretty simple as far as the process to go about getting them. You get them, you get the works, you file them. Copyright office will make sure that it was properly filed and that everything checks the box. You wait about 3 to 6 months after it's filed, and you'll get a registered copyright. So there isn't a lot of back and forth. Unless it is one where this doesn't really meet the requirements for copyright. So you're trying to do like a logo, trying to get a copyright on it. That's really going to be under trademarks. Or if it's using somebody's underlying work and you haven't given proper or clarity as to who created what. But by and large, most of the time copyrighted works, as long as it is an original creation, pretty simple process. All right. Trademarks, last one we'll hit on. So trademarks mentioned, this is going to be protecting our branding. Branding can be pretty expansive. Looks like I didn't update or messed up on updating the slide. It should be writings, artwork, and music. That's there goes back to copyrights. But this one should be generally it's going to be a word, a phrase, or a look. Those are the typical ones. So name of a company, name of a product, catchphrase, logo, those are the typical trademarks. So if you take Nike as an example, they have the word Nike as trademark, they have the Nike swoosh, they also have just do it. Those are kind of the typical ones. Can be more expansive. So you can also do trademarks that are on for sounds. So if you take whether it's Windows or Apple and they boot up, the noise that they do, bum or whatever it be, those are actually popular trademarks. Noises or sounds because it was unique and it was a branding element. They'll have football teams that have either red field or blue field or other color variations. Those are actually trademarked because people associate that color field specifically with that team. You'll have other ones as an example. Mary Kate, I don't know if they're still popular or not, but for a while there, you sold enough Mary Kate, you got a pink Cadillac. Their color of pink on the Cadillac was a trademark because it was unique. And when people saw that color of pink Cadillac, it represented Mary Kate. So there are more expansive elements to trademarks. Vast majority of the time when you're looking at a trademark, it's either going to be a word, phrase, or a logo. Mentioned it on that. You have to be careful. A lot of times, you always get people when I talk with clients that are kind of on 2 ends of the spectrum. If you're the creator of the brand, you want to own it outright. You want to stop anybody else from using it, and you want to have entire exclusivity to it. On the other hand, when you're the startup business and you want to go and leverage a brand, everybody always gets frustrated that they can't go out and use somebody else's brand to build their business on top of it. So one of the more recent examples is how many people have ever tried freeze-dried candy? Freeze-dried candy, it's funny as it sounds, I've had plenty of conversations about it, because when you, let's say, take Skittles as an example. If you were to put on the packaging freeze-dried Skittles, you now just are violated Skittles or trademark, because it looks like you are now saying this is a Skittle product, you're using their branding. You can put Skittles as part of the ingredients or things that go into the product as part of that ingredients list, or you can but most of the time, if you use Skittles as a part of the predominance of the brand, I've had several clients, they get the nice or not so nice cease and desist letter that says you cannot put this on your branding because it makes it look like this is a Skittles product. So you do have to worry about when you're using someone else's brand. Generally, unless you have a license, you have rights to it. If it is an association, it looks like it's tied together. The standard for whether or not something is trademarkable and or whether or not you infringe someone else's trademark. Or tell you, anybody have a guess as to if you're to decide whether or not something is trademarkable, whether or not you infringe anybody else's trademarks, what would that standard be that you guys would set? How do you determine, hey, is it fair that somebody, or that, can I go get a trademark and is it different enough from somebody else?
It can't like be almost, I would say identical. So like if you just change the Skittles L to an uppercase I don't think that would be right.
Ones if I put, and I get this question on that. Ones if I put that in front of the Skittles.
Skittles, I still think that's kind of identical because it's like Skittles, that's them.
Ones if I put a dash in between letters. I mean, these are questions I get on almost a weekly basis, which is, if I'm the owner of Skittles, I would say, no, that's not fair. And yet everybody says, well, ones if I just put a Skittles with a Z at the end, or ones if I put a dash, or ones if I don't capitalize it, or ones if I put all of those are going to still get you in trouble. The standard for whether or not something is trademarkable, same standard for not whether or not you infringe someone else's trademark, called confusingly simple. Confusingly similar basically means if a general consumer in the public were to see your brand and see the other brand where they think there's an association, there's a tie together, it's the same company, same or provider of the goods. You can reasonably, consumer to reasonably distinguish from it. You're able to get a trademark and not infringe someone else's. You put a dash, you put a Z, you put a change of letter, you put the in front of it. People are still going to think the Skittles is probably a Skittles product. So that's generally what you're going to be looking at for standards for trademark. Kind of walking through and wrapping up, because I think you said 10, 15. So kind of giving the idea on the process. So the first thing is you're going to look kind of like for patents, you're going to look and say whether or not something's trademarkable. A couple different ones. Distinctive, that's kind of that confusingly similar standard, has to be able to people to differentiate who is selling the products or services. Really the genesis for why trademarks are out there is it allows you to understand who is actually selling the products and services, so there isn't a confusion between a lot of companies selling the products. So when you go see Nike, you know that Nike is selling it. When you see Adidas, you know that Adidas is selling the product. They're both shoes, but you know that maybe difference in style, difference in quality, difference in customer service, but you can know who is selling the product, and it allows you to distinguish these or the providers of products or services in the market. A couple other standards, can't be too descriptive. Example I always give is if you're to go and open up a fruit stand, you're to sell the fruit apples, and on the front of your fruit stand, you put the word apple. You couldn't go and trademark apple, or when you're selling it, or apples at the fruit stand, because people are really just going to think you're describing the product you're selling, which is apples. That's not your brand. Now, go start a smartphone company, you can or trademark as Apple, because people aren't going to be confused as Apple is a brand for smartphones. So it can't be too descriptive. You can't just simply describe it. Another one would be really cold ice cream, or I think I have up here cold ice cream or ice cream. You couldn't trademark or cold ice cream because you're really just describing this product you're selling, which is cold ice cream. Generic is another one. You can't just use everyday or well-used terms within the given industry. You can't trademark those. Can't be or they're deceptive. You can't try and intentionally trying to mislead people with your trademark. So those are the standards. You can do a trademark search similar to patent search. You don't have to, but it kind of let you know if there's any other likely trademarks that are going to be an issue. You then prepare and file the trademark application. Usually right now, trademark office is getting slower rather than faster. They're getting more backlogged. Blame China because they're a bad actor and they file a lot of frivolous trademarks. But right now you're going to be at a queue about 7 to 9 months after you file your trademark before you hear back. Then you're going to go through an examination process where examiners are going to go out, look at the other trademarks that are out there, see if there be any likelihood of confusion between them. You may argue back and forth with the examiner. The examiner is convinced, then it goes to a 30-day publication period. Basically, it goes out to the public in so many words can say, hey, we think the examiner got it wrong. This would be an issue with our trademark. And you can argue with those specific people. Otherwise, after it goes to the 30-day period, you'll issue it. Trademarks don't expire as long, or with the exception, you have to pay maintenance fees, you have to continue to use them. If you stop using them, then you're going to lose your trademark, or if you don't pay the fees, you're going to lose your trademark. As long as you do those two things, you do have to submit evidence to the trademark office on a routine basis, showing that you're continuing to use it. As long as you keep doing that, you can own trademarks for as long as the business, as long as you keep. Didn't have time to go through the myths, so you're welcome to share the name of those are kind of some of the common myths that we hit on. Last thing is if you ever want to reach out to me, there's my contact information. Easiest way is if you ever want to, strategymeeting.com is just links to my online scheduler. So that's it. I think we're at time. Happy to I'll be around for the next class as well. So you're welcome to come up and ask any other questions you might have. Otherwise, thanks for everybody's participation.
All right, let's give Devin a round of applause. Canvas everybody has access to. Probably saw an announcement that went out last night. I reviewed the exam, made some minor adjustments. I also published interim participation grades to give you a sense of where you're at. Let me know if you have any problem with either of those grades. If you'd like to review your exam, we'd be happy to meet with you. And we're going to talk in class about the question or two that many people missed. But we will not be doing that until next Thursday. Yeah, I'm not sure if I mentioned this yet, but I'm canceling class on Tuesday. And I'll explain more in the announcement, but just so you can start to plan. We won't be meeting on Tuesday. We'll pick this back up, starting with an exam review and any discussion you want to have about participation rates at the beginning of class on Thursday. All right.
Thanks for bringing those back up.
That's great. Thank you for your support.
Absolutely.
So you really have people trying to patent?
I mean, they don't call them perpetual motion machines, but they'll be like, well, it basically creates free energy. And I'm like, usually I hear that, I'm like, so that's a red flag. I'm like, now there are some people that they get confused. And it's like, it's more efficient way or it's energy efficient, not free. But no, I've had people that are like, it'll make free energy out of this. And I'm like, look, I can tell you right now, the likelihood that you're going to overcome the laws of physics is pretty low. You have, and then I'm like, have you made it? Have you actually proven that it works? No, I'm like, but I'm convinced it will work. It's going to work. And I'm like, make a prototype. If you can prove it, I'm happy to help you. But the patent office summarily has said, this is not a patentable invention.
There was some research paper from China, I think, a year ago. Like they come up with a superconductor or something that could superconductor that work in room temperature. They weren't claiming that it's the energy, but basically like something very close to free to wire like. Yes, this already exists, but it has to be like. And it got some traction, and everybody was skeptical. And it ended up being.
I've come up all the time, but I bet I've had over my career people that take some variation of it. I'm like, that's awesome. I hope you can do it because you'll make a lot of money, but the likelihood that it's going to work is really small. Yeah, but it's always funny. And you can tell about the first 30 seconds. You're like, so you're thinking that you've overcome the laws of physics? Like, yeah, I can tell you how it's going to work. go out, build it, then.
Yeah.
It's funny. I haven't had anybody that's pitched me for the cure for cancer yet, so that was. Treatments I've had.
That's funny.
Oh, sorry.
It's funny that. Just said, don't even try. Cause like, that's not the same as perpetual motion, so if you could. Cancer, it's not quite.
I think that, and I said, I think if you would actually want to improve it, like, hey, here's my studies, here's my research, still say, okay, you get a
They
pass
just don't
on it.
want
But
like,
it's just, I think the number of people that are just trying to.
my garage adventure thing, like, I've
Exactly.
got it.
Because they're just, you're, you know, zillionaire, you're gonna make
Yes.
a lot of money, and so I think everybody is finally, and they're just saying, we're getting so many of these crappy type of patents. We're just saying this isn't patentable, don't even bother.
Yeah.
So that is interesting.
Once you have on the agenda today.
Go back and.
Yeah.
Nothing too exciting. I think I have a podcast episode that I'll be recording, work on some client stuff. That'll be about it. Pretty typical day.
That's crazy.
Nice.
Yourself?
I'm doing this all day. I've got 2 more ethics classes after these law classes. My wife is actually guest lecturing in my ethics class. She's a lobbyist. Lobby.
I'm sure that makes her a lot of difference.
Yeah, so it's gonna be old school today.
Got it all in a nice
Oh, or how many classes or how, or?
I teach 4 classes, Tuesdays and Thursdays,
Yeah.
9 to 2:45. So usually kind of dedicate my Tuesday to groups. Other stuff. Friday.
Good load?
Yeah, yeah. Cool.
Yeah, right now, I want
Convention.
also, right now.
It's a dividend. I think that
Oh,
it doesn't pop up anymore. It's been used enough, but it's basically like.
Like in my old-
One of the areas that has the most active outlets going on is. Because you get a lot of lawyers, doctors, and attorneys that are saying, hey, I do golf and I came up with the dimension, I have the expendable income and I want to be able to tell my buddies that I have a patent on something. And so that's probably the number one area of patent that are filed. But yeah, that one's just
You need like